Garrett McKean ran for city council in Blythe, California, in 2024. During his campaign, and even more so after the election, he experienced escalating harassment, intimidation, and multiple civil rights violations by local law enforcement. What started as a run for change turned into a personal battle against a broken system. This is a docuseries documenting his encounters with the very departments he once sought to reform. In April 2025, Garrett McKean filed a $1.25 million federal lawsuit against the city of Blythe and multiple individual officers alleging violations of. This is his story. This is what happens when you stand up to power. This is Blythe, California. December 2024. Traffic incident. In December of 2024, McKean was involved in a traffic collision after another driver allegedly ran a stop sign. After calmly exchanging information with the other party, McKean chose not to contact law enforcement, citing a well-founded concern that doing so would result in harassment, escalation, or an unlawful search. When officers arrived unsolicited, McKean fully complied while clearly asserting his constitutional rights. At no point prior to being placed in handcuffs was he informed he was being detained. What followed appears to confirm the very abuses he feared. As of April 16, 2025, McKean's federal civil rights complaint is pending with the U.S. District Court for the Central District of California. The documents have been submitted and are currently awaiting formal processing and assignment of a case number by the court clerk.
Yeah, do you have any other questions for me?
Is this vehicle operable?
That's why my wife's here to see if we're going to check all that out.
Okay, well, I need to be here because it's in the roadway. It's obstructing the roadway.
This is obstructing the roadway?
Yes, sir.
All right, let me move it forward for you. All right, I'll move it forward for you.
Right?
You're right. You got me there. That's why I'm moving it. Can't even open this door. Okay. Oh, we got the whole band together, huh?
In the initial moments of contact, the responding officer accuses McKean of obstructing the roadway and allows him to move his vehicle, a clear indication that the officer did not suspect McKean of being under the influence. Once McKean's name was run through dispatch, at least 7 officers arrived on scene, despite no evidence of criminal activity. The officer then explains that field sobriety testing is voluntary. McKean exercises his right and declines.
Drivable while she follows me.
Okay.
You guys good? You need anything else?
Real quick, it's a question. You don't have to. Would you roll? Do some field sobriety tests. You don't have to. Would you roll? 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 You don't have to. Would you? You don't have to. Would you? You don't have to. Would you? You don't have to. Would you?
Didn't even cause the accident.
So just let us do our deal.
Yeah, no problem. You guys go ahead and do your deal.
You're going to be here. You're part of it.
Oh, I'm being detained?
Are you
Am I being detained?
a driver?
Or am I being detained? I don't answer questions.
Okay.
Here, take this.
You all right?
Yeah, all right. It's fine. We got a body cam.
Are you the driver?
Oh, God, it's Ed
You the
McCormick.
driver?
I don't answer questions.
McKean was placed in handcuffs despite never being told he was under arrest, and after asserting his constitutional rights. This moment is one of many now detailed in a federal complaint filed with the U.S. District Court in April 2025. The lawsuit names multiple officers and city officials, citing over 20 prior complaints involving harassment, 15A. Plaintiff was not pulled over but was approached by officers while already parked following a minor traffic collision. An officer informed plaintiff that participation in field sobriety testing was voluntary. Plaintiff declined to participate, invoking his rights. 15B. Despite this, plaintiff was placed in handcuffs, searched without a warrant or probable cause, and had his personal body camera unlawfully seized. Defendant Detective McCormick subsequently threatened plaintiff, stating that failure to comply would result in arrest and driver's license suspension. 15C. Plaintiff clearly invoked his Fourth Amendment rights and verbally objected to any search or seizure. These objections were ignored. The detainment, physical restraint, and seizure of property occurred without any articulable suspicion or legal justification, constituting an unlawful detention and violation of plaintiff's constitutional protections. Shortly thereafter, Defendant Detective McCormick arrived, escalated the situation, seized plaintiff's personal body camera, and detained him. Plaintiff verbally invoked his Fourth Amendment rights, clearly stating he did not consent to illegal searches or seizures. Despite this, Detective McCormick physically reached for and took plaintiff's pulse without consent, violating plaintiff's bodily autonomy and Fourth Amendment protections. Plaintiff was also threatened by McCormick that if he did not comply with further questioning or testing, his driver's license would be suspended.
Yeah. So, McCormick? It's like a dream scenario for you.
Honey,
Yeah, babe.
I gotta go put gas in my car.
Don't-
Tell me I'm not allowed to touch the car. Okay. Wait, do I have your wallet?
No, I need you to record. I need you to record what's going on. They haven't even told me I was detained or what I was being arrested for.
You're detained right now.
So,
You're gonna trip, you're gonna trip.
you're pulling me. What do you want me to do?
I know, but
You want to just take that off?
you're gonna fall
Would it be
back.
easier for you? You could
No,
just
you-
untie it. And then,
Do you want her to take this?
yeah, could you please?
You're not gonna get cold?
No, yeah, it is cool. I want it.
No, I'm talking to him.
Well,
Because it's his.
he's not doing anything. You can rest.
Okay.
No. Like I said, they give me a choice whether they answer questions or not.
Space the unit, you're not being cooperative right now, okay?
You have the right to speak, question, criticize, or even verbally challenge police officers during an encounter, as long as you're not threatening or physically interfering. The First Amendment protects a significant amount of verbal criticism and challenge directed at police officers. The court struck down a city law that made it illegal to oppose police officers verbally, ruling it unconstitutional.
No, I'm good.
Okay, stick your
I don't agree to any searches or seizures, and I don't.
I don't agree to any searches or seizures, and I don't. You're gonna take. That is illegal. I don't know what that is. That's my
It's a body
cam.
cam.
You stop me from recording. That's illegal. I'm not looking at you. I would like to be.
I need my husband.
Seizures, and I don't. You're gonna take. That is illegal. I don't know what that is. That's my
It's a body cam.
You stop me from recording. That's illegal.
After violating McKean's Fourth Amendment rights, Detective McCormick places him in the back of the cruiser. It is there McCormick delivers a clear ultimatum: comply, or be taken to the station and lose your license. This is not public safety. This is not reasonable suspicion. This is coercion. The threat of arrest and license suspension for exercising protected rights is a constitutional violation. Courts have ruled that law enforcement cannot punish or pressure individuals simply for invoking their rights. This moment may constitute a violation of Fourth Amendment, protection against unreasonable search and seizure. 14th Amendment, due process and freedom from coercive punishment, California Civil Code, paragraph 52.1, Bain Act. Coercion or threats intended to chill civil rights. After McKean clearly invoked his Fourth Amendment rights, Detective McCormick reached in, shined a light in his eyes, and checked his pulse, without consent. Physical contact following a verbal assertion of rights is not just invasive, it's a potential constitutional violation. If a law enforcement officer violates clearly established rights, like bodily autonomy and protection from unreasonable search, qualified immunity does not apply. That means Detective McCormick could be held personally liable in federal court for unlawful physical intrusion and coercion. This wasn't about law, It was about power, and this is only the beginning.